All right. Morning, everyone. Sorry for getting a late start here. Just had to switch the PowerPoints. My name is Robert. I'm one of the two lawyers at the Tenant Resource and Advisory Center. I'm doing the first half of this presentation on the housing law update for 2022. Susanna, who you all met at the plenary yesterday morning, will be doing the second half. So the first half is mostly going to be legislative and policy updates. There haven't been that many important ones, at least. There is going to be more in the case law update section, but you'll see that as we go through the slides. So without further ado, because we're already 6 minutes behind, here we go. So changes to the Residential Tenancy Act and Regulation. There's really only one legislative change. Section 51.1 has finally come into force. So 51.1 is the compensation for tenants when landlord does not follow through with the stated purpose for ending the tenancy in a vacate clause in a fixed term tenancy. So we've had this penalty for misuse of landlord use notices. It was not in force for vacate clauses. Now it finally is. So similar sort of requirements, tenant can apply if steps have not been taken within a reasonable period of time to satisfy the prescribed circumstance. And if you'll recall, the only permitted prescribed circumstance is that a landlord or close family member wants to move into the unit at the end of the fixed term, or that unit is not used in a way that satisfies that circumstance for at least the period of time prescribed under Section 97. All that means to say is that the timeline, how long a landlord has to use it for that purpose, is going to be set out in the regulation, and we will get to that. And there's also more in policy about how to interpret this. But the one takeaway from the legislation is that here the burden is on tenants to prove that the landlord has not followed through with that stated purpose on the vacate clause. So they've amended the section for landlord use penalties, landlord use eviction penalties, where now landlords have that burden, but the burden is on tenants for these claims because they like fairness, but not too much fairness. Also very important, it's not, as we get into in policy again, it's not retroactive. So tenancies that have already ended by vacate clause do not qualify for this compensation. Tenancies that have an existing vacate clause may, but we'll talk about that a little bit later. The next section here is the changes to the Residential Tenancy Regulation. In short, there's been a change made. We'll see this in the Manufactured Home Park Tenancy Regulation as well. There's a specific change to the 2023 rent increase. So effectively the government didn't want to change the overall formula, but they wanted to limit the rent increase for 2023 to 2%. Because inflation is going to be higher than that. And that's usually how you calculate the allowable increase. So effectively, it states that the increase is going to be 2%, and the section comes out of force at the beginning of 2024. So it's just going to be for this 1 year, and then things go back to normal. Those are the only two changes to the Act and Regulation for the residential tenancy side. So on the manufactured home park tenancy side, there's only one regulatory change, which is just, again, this same rent increase, although you'll note that the increase is 2% plus the proportional amount that is calculated under the Manufactured Home Park Tenancy Regulation. Okay. I told you there were a few legislative changes. So now we're into the policy guidelines. There have been quite a few updates. Most of them are pretty small, but some of them are more important. So for example, this first one, Policy Guideline 23, incredibly small. So it's about amending an application for dispute resolution. They've literally added these 5 words to let you know that you can apply to amend your application for dispute resolution online. No longer do you have to take the paper form down to the branch or to the Service BC office. We have entered the 21st century, kind of. So Susanna actually alluded to this at their presentation yesterday. So policy guidelines 24 and 25 about review consideration and request for clarification and correction. Both have this paragraph included. These paragraphs are put in because the RTB is now recording hearings, and you can request those recordings, as we'll see in a later policy guideline. But these paragraphs have been added to effectively say that a party must not submit a copy of a recording. really, they probably mean a recording of a hearing, but it is phrased very broadly. So in theory, it could be any recording. But then they go on to say in each paragraph that the arbitrators will not listen to it, and except where it would result in a breach of the principles of natural justice, not to listen to it. So practically speaking, what does that mean? You just put it in anyways. If there's no consequence to the only consequence to it being not required to read or listen to is that they won't listen to it. But if it is required by fairness that they listen to it, they will. Fixed term tenancy policy guideline change. They've just sort of added these last two sentences here, again, just to reflect that addition of section 51.1, the penalty for not following through on the prescribed circumstance for using a vacate clause. And although they've also added the 6 months thing, I think that also corresponds to the regulation. So that deadline, the landlord does still have to use it for 6 months at the end of a vacate clause if they say they're going to move in that prescribed circumstance on the tenancy agreement. And so that's reflected here. You'll notice that though that the sentence above it, occupancy can be part-time, e.g. weekends only. That's going to be part of that whole, all those claims for compensation for not following through on that prescribed circumstance. And that's going to make those claims significantly challenging because tenants effectively have to prove that the landlords never lived there, not even on weekends. And that's a very brutally high evidentiary standard to have to hold someone to. All right. So policy guideline 37 on rent increases. They have this particular section on the 2023 annual rent increase because it's going to be a bit different than all the others. It's effectively first 3 paragraphs, very straightforward. It's 2% for RTA, 2% plus proportional amount for MHPTA. The last paragraph there is just about the timing of notices. So if a landlord, for whatever reason, wanted to give a tenant more notice and serve with more than 3 months advance notice increase for 2023. So they served before September 2022. Based on a higher percentage increase, the landlord can now just give another notice with the proper number, but not the same 3 months notice. So let's say, for example, let's say the landlord really jumped the gun and issued it on in September before the percentage was decided, maybe the end of August for January 1st. Let's say they set it at 5% because that's what they guessed inflation would be. The landlord now can issue another notice at any time before January 1st, just with the right number on it, the right percentage increase, and it will still be valid. So they no longer have to meet those timing requirements. You can imagine it effectively they're serving an amended copy, but they don't have to meet those same deadlines. Policy guideline 41 on administrative penalties. This is one that got a pretty significant rewrite. A lot more content and more legibility. But in general, it's not going to be super relevant to the work that advocates do because it's more about telling how the branch is going to calculate administrative penalties when it levies them against parties. You can't ask the branch to assess an administrative penalty. It's their decision whether to do it. And once they decide, and they use these sort of tools, this framework in this policy guideline for deciding how much to enforce. It's something to be, I guess, aware of when you're making like a complaint to the compliance and enforcement unit, thinking about like how much weight the RTB can come down with. Perhaps relevant if you're assisting a tenant who's having an administrative penalty levied against them for something they've done. It's less common. Most of them are going against landlords, but you never know. But it's generally not relevant because even where it's assessed, the RTB keeps the money. So it's something to be aware of, and for just some light reading if you're looking for something to peruse. Policy guideline 43 is super helpful. I actually don't know the update section on this that lists when it was created and updated seems to be kind of wrong. I don't remember this existing. It's incredibly useful, and it's something everyone should review before making your next RTB claim. So it's effectively about how to correctly name parties when you're making claims against them at the branch. So there's a section on different kinds of parties and how to name them. So we have this first section, for example, on individuals as parties, making sure, for example, you're using their legal name to the best of your knowledge. Or if you're not sure what name they're using or what name might be legal, use every name you have for them with AKA between them. The real thing to keep in mind is if you get an order against someone, but it doesn't name them with their legal name, it's useless. You cannot enforce it against them. You likely will not be able to do anything with that order unless they decide to comply out of the goodness of their hearts. So it's just another example to be very diligent with naming. If you don't know, research it as much as possible. Do as deep a dive as you can to get that legal name. And if you're unsure, you can't choose between different options, put them all in. And if you think it's all refers to the same person, AKAs between them, if you think it might be different people, list them in sequence. Just know that you have to serve every different individual. The section C, businesses as parties, so how to name businesses in RTB hearings, is the one that's seen the most significant addition or rewrite. Very important as well, sort of for much of the same reasons, because if you name the wrong company or name a company incorrectly, it can be impossible to enforce against them later on. The section that's been specifically added is that third paragraph about sole proprietorships. So it says that a sole proprietorship or business that is not a registered corporation or limited liability company is not considered a legal person. So effectively, because of that, you can't really name them on their own as a respondent. So when a person is just doing business as an entity, you use the kind of wording you see at the bottom of that paragraph. So John Smith, DBA, doing business as Garden Apartments, or John Smith, COBA, carrying on business as Garden Apartments. Now, if you're not sure, just name them all. Name John Smith, Garden Apartments, and maybe John Smith doing business as Garden Apartments. It doesn't hurt to add. The only detriment to putting in more names is you just have to serve more people with the notices of dispute resolution. But you don't want to end up in a situation, for example, where you're helping a tenant with something like a 12-month rent claim for the landlord not following through. You don't name a party, or you name a party incorrectly. Now they have an order that they cannot enforce, and they likely can't go back to the RTB to ask for another one or to get another kick at the can to name the right person. So very important to be diligent about it. And if you have any concern about naming at all, read this policy guideline before you make your next application. And I guess finally, there's another part of this policy guideline that's very interesting about correcting a decision or order where the party is named incorrectly. So if you have gone through and a mistake has been made, a party's been named incorrectly, maybe you got a tenant who made their own application and misspelled their landlord's name. The RTB does have the power to amend naming within tight limits. Effectively, it's important to read through all of this. The short version is, you can't use it to add a party that wasn't served. You can't use it to change the name to a party that wasn't actually there. And you can't use it to fix a problem that could have been fixed by reasonable diligence at the outset. But let's say, for example, you had a tenant who made the application. They named their landlord as they're named on the tenancy agreement, but the tenancy agreement actually doesn't include their full legal name. And all you need to do is just change something from Dave to David. Because you can't enforce against Dave when his bank account says David. That's a situation where the branch may be able to assist on a clarification or correction. But it's a last-ditch effort. It should only be done, and they're not going to do it very often. So an ounce of prevention is worth a pound of cure in this case. All right, so policy guideline 44 about the format of hearings. This is the only addition, this last paragraph, circled in highlighter, about the requests for alternative hearing formats. They effectively are saying that they're clarifying to say you can ask for an alternative hearing format after you've made the application, which didn't used to be the case, or at least it wasn't clear that it was the case. It's important to consider whether your client has any barriers or there's anything that would make it difficult or impractical or unfair for them to have to attend a hearing over the phone. In-person hearings are quite rare. I have never been to one, but I have heard of them. And if you should consider whether your client, it's in the needs of the interest of justice and them getting a fair hearing, to have it be in person, generally is going to require something like a disability that will make it hard for them to attend over the phone. I think in the case of the one time I've heard of an in-person hearing was where a tenant had a hearing disability, which would make a phone conference very challenging for them. All right, remind me the microphone stand. So policy guideline 47, we're just ripping through them at this point to get to all the case law. It's about access to records and information. And this is the section that's been added about obtaining a recording of your dispute resolution hearing. So let's say you've gone to a hearing, you've got one of your favorite arbitrators who's just gone off the handle and screamed at your tenant for 15 minutes. You probably want that recording, if for nothing else, so you can tell the RTB to listen to it and think about, disciplining their arbitrator. This section sets out how to make that request. You can only make a request for some reason 20 days after the dispute resolution hearing has been concluded. That's the hearing been concluded, not the decision. Although practically speaking, I'm not sure if they're forcing you to wait until after the decision too. Well, hard to say. But best just to get a request in when you can, if you're interested. Practically speaking, if you think your client might need that recording for a judicial review purpose to establish that something procedurally unfair happened in the hearing, it's likely not going to be possible to get that recording in time for the filing deadline, but you can always, that the client can still use it later. So it always might be useful. And you might just want it yourself to, as long as you get your client's permission to get it, you can even just get it yourself to be able to listen to the hearing, review it, and consider what could have been done differently or how things got off the rails, anything like that. There are some rules as well, I think, in this policy guideline about sharing. There it is, that second paragraph on the bottom. A person who's given access to a recording must not alter, copy, distribute, or publish the recording unless authorized in writing by the director of the RTB. So don't post it on Facebook, and don't tell your client also not to post it on Facebook. This policy guideline 49 about tenants' direct request for the return of security deposits has been revised for clarity. I didn't want to reproduce the whole thing up here. It should suffice to say that if you are assisting a tenant with this claim, it is a good idea to read through this policy guideline. It'll go through sort of what the formal requirements are for making this request, what kind of evidence you need to include to be successful. All right, policy guideline 50 about compensation for ending a tenancy. This has seen the update related to 51.1, that vacate clause penalty. So these last two paragraphs, you see there that the first paragraph talks about how the onus is on the tenant with a 51.1 claim to prove that the landlord has not followed through with that prescribed circumstance for ending the tenancy after using a vacate clause. So they're being very explicit about it. And this is the section on the transition. So this is kind of about retroactivity. So the important section, so they are correct in saying a law does not apply to previous circumstances unless required by legislation, but amendments can apply to ongoing circumstances. So effectively, section 51.1 can apply in those cases where the agreement was entered into before 51.1 was brought into force, but it hasn't been ended. So the arbitrator has the discretion to decide that it does apply, but they also could decide it does factor into the extenuating circumstances analysis, which we'll get to later. But effectively, if someone's vacate clause is already kicked in before the 51.1 came into force, no compensation. The tenancy is still ongoing, the vacate clause has not yet kicked in, you can still apply for compensation, but it will be harder. And of course, tenancy agreements entered into after 51.1 came into force, it's fully in force. And here's the part about extenuating circumstances. This is the part that effectively says, to sum it up, if there's an ongoing tenancy, the vacate clause hasn't kicked in yet, you can still make the claim, but they're going to interpret it in a way, the interpretation of extenuating circumstances is going to heavily favor landlords. So they give an example here. I've chunked out parts of this section just to keep the ones in that relate to the vacate clause. So a potential actually extenuating circumstance that could properly relieve a landlord from paying compensation is that they only intended to move in for 3 months when they signed the agreement, and now, now that the effect is coming into effect, it requires 6 months. So it's if that is the kind of thing that's going to be accepted as an extenuating circumstance, it's going to be almost impossible to get these kind of compensations for tenancies that were entered into before the 51.1 came into effect. So it's important to have that reality check with a client who might be thinking about bringing that claim. And finally, policy guideline 54. This is a new policy guideline that people like groups like TRAC and CLASS have been asking for a long time. Finally got it. It's not as useful as we thought it would be or wanted it to be, but that's the RTB. 2 steps forward, 1 step back. So this policy guideline is about the arbitrator's discretion to set the end of a tenancy when issuing an order of possession. So arbitrators have the discretion when they're upholding a notice to end tenancy to set the date for that order of possession. As you probably know, if you've done RTB hearings, 99% of the time, they will just default to the minimum, which is two days. But they have the discretion to extend that. And this sort of policy guideline talks about the factors that they may consider. So it's not binding, unfortunately, but it's the kind of thing you can point the arbitrator to and say, look at these factors and why you should extend the deadline. So for example, the point up to which rent has been paid, the pre-existing length of the tenancy. So if they've lived in the unit for a number of years, they may need more than 2 days to vacate the rental unit. I'll say if you've lived in a rental unit for more than 2 days, it's going to take you more than 2 days to vacate the rental unit. But and any evidence the tenant provides that it would be unreasonable to vacate the property in 2 days. So if the tenant provides evidence of a disability or chronic health condition. So that's something that any kind of arbitrators, I think it was always good practice to do this, bring up to the arbitrator at the end of the hearing, here are all the reasons you should not evict my client. But if you do, you should give them at least X number of days beyond those 2 days in order for it to be fair. You can now at least point them to a policy guideline when making that argument. We'll see how effective it is. We'll see how much it actually gets them to consider it, but at least there is something in writing that that you can refer them to. Sweet, we're not even at 9:30 yet. Now we have lots of time for the case law, which is good because there's lots of cases. I'm doing the first 3 and Susanna's coming up and doing the rest. Yes, excellent. Questions at the end, I promise. All right, this first case, McLintock and British Columbia Housing Commission. So this is a case that involved a 1-month notice to end tenancy for cause for breach of a material term of the agreement. So Mr. McLintock received a valid notice of entry for his landlord to come in and do renovations on March 29th, but he believed it wasn't authorized. So he changed his locks and put a no entry sign on his door. The landlord was a bit miffed, put a letter on his door saying that he had until April 5th to talk to the landlord about this breach, or they would issue a 1-month notice for cause. He never got back to them, but he did change his locks back before the 5th. So because he didn't talk to them, the landlord issued the 1-month notice, checked the box for significant risk and breach of a material term that hasn't been corrected within a reasonable time. The landlord then later issued a new notice of entry for May, and the same thing happens again. He changes the locks, puts a note on the door, landlord issues a warning, then he changes the locks back the next day. It goes to the hearing, and at the hearing, the arbitrator upholds the 1-month notice solely on the basis that he's breached a material term of the agreement by not providing access and not correcting the issue within a reasonable period of time. So the tenant judicially reviews this himself. And there is an important fact, but one last important fact before we get to what the court said, is that before the judicial review hearing, he did actually let the landlord in to do the work, do the renovations. That's a very sympathetic fact that I think helped the outcome of this case. But the court held that it was a patently unreasonable decision for the arbitrator to uphold the notice. Specifically, they looked at the requirements for ending a tenancy with a 1-month notice for breach of material term and that reasonable time requirement. So there not only has to be a breach of material term, there also has to be a failure to rectify that breach within a reasonable time. So the court talks about that at paragraph, sort of copies paragraph 54 to 56, the most important parts. That second sentence there, this begs the question of whether the 2-day time frame to come into compliance was reasonable. So the arbitrator was obliged to address that. They had to consider that. And in the decision, the arbitrator does very briefly, effectively in a list of things he says he finds, does say that he thinks that the tenant did not come into compliance within a reasonable deadline, but didn't provide any sort of reasoning why. In paragraph 55, they go on to say that the arbitrator was required to assess whether the time dictated by the landlord was reasonable given all the circumstances, and that included Mr. McLintock's specific circumstances, including his advanced age, his disability, and his status as a long-term resident. So those are all things that the arbitrator had to consider. There's no evidence he considered them, and that ultimately rendered the decision patently unreasonable because the court found there just, it was the arbitrator had not done their job of applying the law. And paragraph 56 is also a nice little capstone on this, and it's starting to, there's a trend of these cases that are starting to talk about this. It started back in 2020 with the Guevara and Louis case, another very useful case that should go in pretty much every 1 month notice for cause eviction dispute, and maybe more, about the sort of remedial purpose of the act and the sort of extreme power of section 47. So it talks about, the reasonable time has to be interpreted in the context of the fact that the RTA protects tenants. And as the court says there, in discerning what constitutes a reasonable amount of time for a tenant to correct an alleged breach of material term, arbitrators have to bear that protective purpose in mind. Which is very useful, I think, especially if you have a case where the tenant with sympathetic facts, even with a tenant that changes the locks frequently and without notice to the landlord, if there are sufficient sympathetic facts that sort of point towards a longer reasonable period, that's a very important argument to make and a very good case to make it with. Ooh. All right, Ryan and Mole Hill Community Housing. So Ryan rented in subsidized housing. His tenancy and subsidy agreement set his rental contribution at $551 a month and the subsidy contribution at $646 a month for a total rent of fill in the blank. It's a little morning math question. I'll tell you, it's not $1,530 a month, but Molehill purported to terminate his subsidy on the basis of a change of household composition, served a 2-month notice for not qualifying anymore, but also demanded he pay the full economic rent of $1,530 a month plus utilities. He goes through, he disputes that notice and wins, but that's not what this case is about. This case is about how much was his rent and what did he actually owe, because he paid the $1,530, but argued effectively that nothing in his agreement says that's what the rent actually is. His rent is just the month of what he pays plus the subsidy, and so he files to get back that overpayment. And they go to hearing, and the arbitrator dismisses his claim, sort of noting the evidence only showed what he paid and the subsidy, but concluded without further explanation that he hadn't made out his claim. And the arbitrator writes this paragraph specifically. And if you had cases with tenants in subsidized housing or arguing about rent, you likely have seen some sort of similar decision that the arbitrator finds they don't have jurisdiction. Now, this is an error. This is an error because the RGB has exclusive jurisdiction to interpret tenancy contracts. Now, subsidized housing, usually if rent is geared to income, is excluded from the rent increase protections, rent control, but the RTB still gets to decide what the meaning of the contract is. And the arbitrator here throws up their hand and say, well, I can't do it. So they apply for judicial review on that basis. Actually is unsuccessful initially, but the tenant appeals to the Court of Appeal and wins. And this is what the Court of Appeal says. Effectively, the arbitrator and the judge failed to consider the content that was before the actual arbitrator, that you have this contract that says, here's your rent subsidy, here's your subsidy, here's what you pay. And there was nothing to support this $1,530 number. It just seemed to have been dreamed into existence by the landlord, or there was some reference to some other operating agreement with BC Housing, but that wasn't before the arbitrator. And effectively, the arbitrator was asked to interpret that agreement and refused to. And that's patently unreasonable, that they had this job to do and they had to do it. And there is some guidance in this decision on how to do that. It points back to another case from the Court of Appeal on like contract interpretation in a tenancy context. So very useful if you're going to be bringing any dispute about what the amount of rent is, or any kind of rental dispute in subsidized housing. And in the interest of time, finishing my last skill, I didn't change the time. Well, you can look at the slide later, but this sort of ratio here at the end is a good summary of what this case is about. The arbitrators do have jurisdiction to interpret agreements and their terms, even if it's about subsidies or rent amounts excluded from the rent increase provisions of the Act. Last case, I swear, Susanna, you'll have your time for your cases, I promise. Okay, good. LaBrie and Liu is a, what is this one about again? It's a, well, I'll just go through the facts. So LaBrie was a long-term tenant, oh yes, that Liu had attempted to evict 5 times in 18 months before this particular hearing. LaBrie sent a rent payment by e-transfer on March 1st, which is when it was due. But the landlord only deposited it on March 10th. LaBrie believes she sent the full amount, but Liu said it was $1 short. So they served a 10-day notice for non-payment, stating that they owed, but the notice said that they owed the full month's rent, as though they had not paid anything. Because at that point, I guess the landlord took the position, I haven't deposited it, so I haven't received it. In the hearing, the landlord argued that LaBrie, the tenant, had repeatedly paid $1 less than she owed. But LaBrie did not know, first of all, that Liu was arguing it was $1 short until the hearing, because the notice said she hadn't paid any of the rent. She also didn't get his evidence because she was in and out of hospital preceding the hearing. She didn't get to serve any documentary evidence about payment of rent because she didn't really know what the dispute was about, but she did testify she sent the full rent payment on March 1st, testified about the previous attempts to evict her, and testified that Liu had never told her she was $1 late before, and it had never come up. The arbitrator based his decision entirely on the evidence about the deposit 9 days after the rent was due for $1 less than the full amount, and her failure, the tenant's failure to deliver any documentary evidence, and upheld the notice. Luckily, in this case, the court overturns the decision and sends it back for a new hearing because the arbitrator had unfairly reversed the burden of proof. So that part of the analysis where the arbitrator said, well, the tenant, you haven't provided me any documentary evidence of you paying the rent. We only have conflicting testimony. Because of that, I resolve it against you. That amounts to improperly putting the burden of proof on the tenant. And as we all know, in an eviction hearing, the burden of proof is on the landlord. And that's sort of summed up here in paragraphs 32 and 33, those highlighted sections. And again, we see this in paragraph 33, the RTA seeks to protect tenants from arbitrary evictions as evidenced by provisions that require thresholds of tenants' misconduct that is significant or unreasonable to support eviction. So this joins that sort of cavalcade of cases that are starting to talk about this, that there needs to be more serious misconduct, heightening the bar in the court's mind on what needs to happen before someone is evicted. The court also, very interestingly, says that the arbitrator needed to have considered whether the doctrine of equitable estoppel applied. So estoppel in this case might have applied because the landlord had previously accepted the $1 less than the full amount without telling the tenant for a long period of time. And even though the court finds that even though the tenant didn't use the specific words equitable estoppel, the arbitrator had to consider it. This also, it's interesting because there's an open question as to whether the RTB can even apply equitable estoppel, but the court implies here that it can. So that does mean that, it's important to make those estoppel arguments when you get them, and the arbitrator has to consider them, if nothing else. The court also very interestingly says that an arbitrator had the discretion to find that rent was fully paid, even if there was a shortfall. So here, the arbitrator needed to ask why the rent was $1 short. There was no inquiry into why. The tenant maybe, I think, speculated about like a bank transfer fee, but there was no evidence about it. There was no questioning. The arbitrator just doesn't find anything about it. Just says it's $1 short, so we're done. But effectively, the court says they have the discretion to find $1 short, still fully paid in light of whatever circumstances are before them. They have the discretion to make that decision. They have to still exercise it reasonably or not patently unreasonably. But they can't simply find that, that rent has been paid if there's no evidence or argument to support it has been. But there's room, a little bit of wiggle room with their discretion. So I think this is a good case to throw in. If you have some case where tenant, you can argue in any way that rent has been fully paid, but perhaps the number isn't quite what it needs to be. If there's some intervening reason like a hidden fee along the way. That's my last case. I'm sure you're tired of my voice, so we're going to give you a new one.
Hello. The first two cases I'll talk about, I actually did briefly touch on yesterday in the plenary, for those of you who were there. The first one is Senft and Society for Christian Care of the Elderly. I would note that this citation is wrong. The actual citation is 2022 BCSC 744. And the case law is, I uploaded all of the case law on Shed, so it's all there if you want to read the cases in full. This is one of the ones I would encourage you to read in full because I think it will come in handy for a lot of advocates. So in this case, there was a tenant with health issues that made cleaning his unit very difficult for him. Before the pandemic, he had a regular cleaning service and his friends also came to help him clean the unit. When the pandemic hit, he lost all of that support. So the rental unit over time accumulated quite a bit of waste, and the landlord alleged that there were sort of biohazardous materials, I guess like rotting food, that kind of thing, strewn about the place. The tenant tried to restart his cleaning service once the landlord sort of expressed his concerns, but the cleaning service had a long wait list because they got backed up because of COVID. So they couldn't start for a while. In between when the tenant contacted them and when they were able to come to the unit, the landlord gave the tenant a notice to end tenancy. The tenant disputed it. So between the time that the tenant got the notice and the time the hearing occurred, the cleaners were able to come and clean up the unit significantly. The arbitrator at the hearing said that that didn't matter. The arbitrator said that all that mattered was whether the landlord had cause at the time that they served the notice to end tenancy, and found that the landlord did because at that time the unit was in disarray. The tenant judicially reviewed that decision, and among the things the tenant argued was that his conduct after he got the notice should be relevant, and the judge in that case did agree. The judge found that arbitrator erred by not considering the tenant's conduct after the eviction notice was served, specifically in the context of the protective purpose of the RTA. And there's a direct quote on this slide from the decision, which is, the evidence that the petitioner cleaned the rental unit was relevant to the consideration of whether the eviction was necessary and justified. By refusing to consider it, I find that the arbiter failed to engage in a purposive analysis of the section 47 under the RTA. So again, this is another judge pointing to the protective purpose of the RTA and saying that arbitrators have a duty to interpret the act in that context. So they can't ignore essentially that the act is there to protect tenants when they interpret it. So this is relevant essentially to advocates. Anytime you get a tenant with notice to end tenancy for cause, where the tenant has taken steps to remedy whatever the problem was after they got the notice. It's also a good reason to encourage tenants to remedy problems when they come to you after already getting a notice to end tenancy. If they haven't taken steps, they can still take steps leading up to the hearing, and it will be relevant. At least you can certainly argue it will be relevant, and you should put this case in those circumstances. There's a question of whether a landlord can use this case to argue that bad conduct post eviction notice is also relevant. I would say it's not, the door on that isn't completely closed, but you could certainly argue, because of the way the judge wrote this decision, that the reason the post-notice conduct was relevant was because of the protective purpose of the RTA. You can argue that bad conduct should not actually be relevant to that analysis. Whether or not an arbitrator will accept that, I cannot predict. Next up, is Cyrenne and YWCA Metro Vancouver. This citation is correct. I I also talked about this one a bit yesterday morning and in longer detail yesterday afternoon. So the facts here were that the tenant was a single mom with an autistic son in a multi-unit building. When before the tenant moved in, she told the landlord her son was autistic and warned the landlord that he sometimes had noisy meltdowns. She asked the landlord to maybe accommodate this by providing her with a ground floor unit rather than above ground floor unit so that it would be less of a problem. The landlord said no, but the landlord still offered her a tenancy in a sort of above ground floor unit. Shortly after the tenant moved in with her son, she began to receive complaints. Hold on, I just got to check my time. Okay, great. As she predicted, I think. And the landlord started issuing her warning letters. The tenant would respond to the landlord sort of, not to every warning letter, but intermittently to tell the landlord the steps that she was taking to try to mitigate the noise, such as putting pool noodles on the door so that her son couldn't slam them, that kind of thing, or any steps she took to dampen the noise transfer between units. But she also told the landlord that she didn't think that the complaints were necessarily legitimate, that some of them were exaggerated, that other tenants were complaining about instances where her son like dropped a cup on the floor and that was it. That was the noise that was being complained of. And yeah, she said, and other complaints were about noise that wasn't coming from her unit because she was home and also heard the same noise and knew it wasn't coming from the unit. So she told the landlord she was taking steps. She also told the landlord, a lot of this isn't even me. Nevertheless, the landlord issued an eviction notice for cause after some time of continually getting these complaints from other tenants. The tenant disputed it. At the hearing, sort of the big problems at this hearing were that right before the hearing, the tenant was involved in a very stressful family law dispute, and she couldn't serve her evidence on time because of it. She served a larger package of evidence 10 days before the hearing and a smaller package about 7 days before the hearing. And as you know, her deadline was 14 days before the hearing. The landlord objected to the inclusion of the second package, but not of the first package. The tenant asked the arbitrator to adjourn the hearing to remedy the problem because the landlord had said, I didn't have time to prepare, so you should exclude the second package. The tenant said, no, you should adjourn so that the landlord has time to look at this. And she explained what happened with her family law situation and why she couldn't serve on time. The arbitrator essentially just told her, no, we can't adjourn because that would be a delay, which of course is what adjournment means. So that was the first problem. The second problem is the arbitrator didn't tell the tenant whether or not he would include the second evidence package at the hearing. So she had no idea as she's going through the hearing whether or not that second evidence package would be considered. And the third problem, is that the arbitrator essentially arbitrarily decided that this hearing would end at 90 minutes and there would be no opportunity to extend that time, regardless of whether or not the tenant was finished presenting her evidence and submissions. And she wasn't. She had considerable more submissions to give. She was denied an opportunity to cross-examine a landlord's witness because the arbitrator had said, hey, we're at 90 minutes, we got to finish up. That's it. She objected to that, of course, but the arbitrator didn't want to hear it. So she judicially reviewed that on procedural fairness, breach of procedural fairness. We also argued patent unreasonableness, but that's not super relevant because the judge didn't really give us reasons on that because we won on procedural fairness. So it was held that the decision should be quashed and remitted back to the RTB. The denial of procedural fairness occurred because the tenant was denied her right to be heard. And here are some direct quotes. There's a lot of good quotes from this decision, but the gist of it is that it was a breach of procedural fairness alone for the tenant to be denied her adjournment request without any reason given why, without the arbitrator hearing any submissions on relative prejudice or inconvenience or anything like that. And it was also another breach of procedural fairness for the arbitrator to just cut the tenant off and not allow her to finish presenting her case when she still had relevant things to present. And in the affidavit that we drafted for her judicial review, we included many things. So she talked about what she could say and why that wasn't enough. And she also talked about what she would have said had she been given the opportunity to finish. And the judge found that to be relevant and even reproduced that portion of the affidavit in the decision. I'm going to go a little bit quick, I think. Okay, so Connors. So Connors was an eviction for cause under the MHPTA. The tenant disputed it. The tenant did not attend the hearing. The arbitrator upheld the eviction notice. The tenant applied for review on the basis that she could not attend the hearing for reasons beyond her control, and she made that application 5 days after she received the decision. As most of you know, there's timelines in the act are a little bit weird when it comes to evictions now, because it essentially says an eviction for cause would be 5 days, but anything to do with an order of possession is 2 days, right? But now, at least for the last, I don't know how many years, quite a while now, anytime an arbitrator dismisses a tenant's application to dispute an eviction notice, they also have to issue an OP. So that's what makes this sort of determining what the timeline is kind of weird because of that. In this case, the tenant applied for review, and the reviewing arbitrator made a finding of fact that the original decision concerned a notice to end tenancy for cause, but dismissed the review consideration application because they found that it was filed outside of the 2-day time limit. The tenant judicially reviewed that decision, the review decision, and the judge found that the review decision should be quashed for inadequate reasons, and the Supreme Court substituted their own decision. So that's something that's pretty rare for the Supreme Court to do, but they did it in this case. So while an application for review relating to an order of possession under Section 48 does attract a 2-day time period for review, the review consideration decision does not link the making of an order for possession to the reason for applying a 2-day notice. This is a quote from the decision. I realize I didn't put quotes around this one. Instead, the reason given should have led to the conclusion that a 5-day time limit applied, and that the petitioner had filed her application for review within time. And it was, I think, fairly key in this judge's decision that there was a finding of fact made by the arbitrator that this was about a notice to end tenancy for cause, and then the arbitrator simply applied the 2-day time limit without explaining why. Okay, I think that's pretty much the takeaway from Connors. Yeah, I guess it's important. I would still suggest that if it's possible to get a review consideration in 2 days, that you do that rather than having to rely on something like this to argue that the time limit should be 5 days. But in the instance where a tenant comes to you and say, I need to review this decision about a eviction notice for cause, and it's outside of the 2 days, but within the 5 days, make the application, put this case in and say, hey, this judge says that if it's a NTE for cause, it should be 5 days, and see what happens, because it could work. I could see it working. Cool. So these are just a few others, and all of these decisions are on SCED if you do want to read them. Most of the gist of these can be summed up real quick, so they're all on the same slide. The first one, Hollyburn Properties and Staley. Essentially what happened here is a tenant applied for compensation for a breach of quiet enjoyment, and the arbitrator sided with the tenant and actually awarded her considerably more than she had applied for in her application for dispute resolution. The landlord judicially reviewed it and won because the judge found that the arbitrator didn't justify the amount that he awarded. The key thing here is that when you're making a compensation application, if you do those, do whatever you can to justify to the arbitrator the amount that you're asking for, because that increases the chances that they will include that justification in their own reasons. Because I think this case stands for not only whether the arbitrator is awarding more than is asked for, do they have to justify? They have to justify the amount regardless. So if you justify the amount in your application, that will help the arbitrator justify the amount in their decision. Dennison, this is a very, very important reminder that a party has to exhaust the statutory review process before applying for judicial review, where the statutory review process can actually address the problems with the underlying decision. So the 3 limited grounds for review, if any of those are applicable to your case, you must apply for review before you apply for judicial review. If you do not apply for review consideration before sending this for judicial review, there's pretty much no chance of success at judicial review. Next, Multani and Brown. Again, this is a very good reminder that submissions are not evidence. In this case, what happened was there was a tenant who applied for 12 months rent as compensation. Landlord attended the hearing represented by a lawyer. Landlord did not speak in the hearing. The lawyer spoke on the landlord's behalf in its entirety. They gave all of the evidence. So all of the testimony came out, or testimony came out of the lawyer, and none of it came from the tenant. The tenant didn't swear that it was true, didn't confirm what the lawyer said. And arbitrator concluded the hearing, and in their decision, they said, hey, testimony, submissions from the lawyer are not evidence. I have no evidence from the landlord, so I'm finding in favor of the tenant. Because the tenant did have some evidence. The landlord was claiming extenuating circumstances as well. So the burden would have been on the landlord to prove that at that time. The landlord judicially reviewed that because they thought it wasn't fair. The arbitrator hadn't told them that there would be a problem at the hearing. And the judge on judicial review didn't for a second buy the landlord's argument. They didn't really understand why this was in judicial review. The lawyer who was arguing it got stripped down by that judge quite well, thoroughly. So this is a very, very good warning. Advocates, do not testify on behalf of your clients. Any facts that need to go in should come from the clients directly. If there's any reason why that cannot happen and you have to say the facts or write the facts down, at least have the tenant testify and adopt what you've said or what you've written under oath. Okay, that's at least one small safeguard against this kind of thing happening. But the best practice is always to have any oral testimony come out directly from the tenant. And lastly, Gordon and Guangjin developments. So this one was essentially tenants got evicted for purchasers' use. So purchasers said they were going to occupy the unit. The landlord issued the eviction notice. The tenants moved out. Purchasers never occupied the unit. Tenants applied for 12 months rent as compensation. At the hearing, it turned out that the purchaser had never given the landlord the written request to evict the tenants, which is a statutory requirement under Section 49. The arbitrator is like, oh, purchaser's not liable, which I guess is sort of fair, but also said the landlord wasn't liable and never said why. In fact, it seemed that the arbitrator didn't even consider whether the landlord should be on the hook for 51(2) compensation, and that was patently unreasonable. The wording of Section 51(2) essentially implies that an arbitrator always has to consider whether the landlord is liable, and sometimes has to consider whether the purchaser is liable where that's applicable. So it's important to note that, especially when you're making these claims, you name both parties, always name both the purchaser and the landlord, because you don't know who is at fault. You don't know whether it was the purchaser who made the written request and didn't occupy, or whether the purchaser just never made the written request. And if they never made the written request, likely the purchaser won't be held liable. You have to go after the landlord in those circumstances. Cool. Did I miss something, Rob? Nope. Great. Those are those cases, and I realize that we don't have a ton of time, but we have a couple minutes if there are any questions. Nope. Oh.
I just wanted to ask. Oh yeah, sorry, mic plus mask. Oh, it's still pretty good. I wanted to ask, just based on a couple of these cases, I wonder whether you think there's kind of an increasing opportunity for advocates to use some of this case law for written submissions in advance of their hearings. I know people probably have variable practice about that, but I'm thinking specifically with regard to the appropriate, like not getting a 48-hour OP, like the appropriate time based on that McLintock case. And also that beautiful language from Senft where the judge is talking about whether the eviction is necessary and justified, and whether you think there's room for advocates to use those for advanced submissions.
100%. And that's sort of why we were going through these cases at these sessions, is that we do think that it's not only possible, but important to do that in your arguments, to include the relevant cases. Even if you don't do written submissions, you can include the case and then make in your oral submissions refer to the case law. And I should add that there is a written submission that we've uploaded this SCED based on Senft. It wasn't written by us. Do you remember who it was written by?
Yes. Yes. Oh, sorry. CCHR. I forget what it stands for.
Okay. Right. So we've uploaded that to Sched. You can use it if you want to make written submissions in analogous circumstances. You don't have to use the whole thing. There's some stuff in there about charter values that you may choose not to use because arbitrators will probably be confused by it, but you can use it if you want.
So online, we had a question. What was the name of the case that, Robert, you cited as useful when disputing 1 month notices?
Oh, the one that wasn't talked about today explicitly would have been Guevara and Louis, Guevara Louie. It's a 2020 case where a judge first really talks about, they give an interpretation of section 47 that says effectively there needs to be significant misconduct and with serious consequences in order for, that's the kind of guiding principle behind section 47. Always good to throw in if a landlord is trying to use a notice for cause for any kind of marginal or minor behavior on the part of a tenant.
And we had one more, a person online said that they had asked the RTB for a recording of an RTB hearing in early September and submitted the request by email. They were named in the application as the agent for the tenant, but still haven't received any response from the RTB, wondering if people have had success in obtaining a recording of a hearing.
We haven't tried it. Anyone here successfully get a recording of a hearing you've done? That's 0 hands.
We've heard, yeah. I think we've heard from others that there are significant delays. So I'm not that surprised by that.
Just a small point, but when you talked about naming parties, are you saying that we can't rely on what the tenancy agreement says, that we have to actually go behind that? Because I've just always relied on what the landlord wrote, which may be a mistake.
I think it depends on what you're claiming for. So if a tenant's just disputing an eviction notice, like the name on the eviction notice should be enough. Like that's because the only order you're going to get there is that it's dismissed. Really, it's most important where you want to have you're looking for an order that's going to compel someone to do something, either a monetary order or a repair order. Repair order maybe not quite as important, but the monetary one is the most important because in that case, the person needs to be properly named. Otherwise, when a tenant takes it to small claims court, it'll be useless. So it's in those kind of cases, there should be a little bit of looking behind the tenancy agreement. It's always hard. One sort of maybe general safe thing to do is to do a title search of the property, see what the name of the registered owner is. And I think that sort of, when we go back to sort of like the Gordon case, right? That's a good case example where like, that's a tenant who did a very good job of identifying everyone that needed to be named, because actually they named the landlord that they knew. The purchaser, the individual named on the 2-month notice was different than the company that actually ended up acquiring the property. And they named both, which is excellent practice. And we didn't even tell them to do that. It's amazing. So that it's, yeah, in cases where money is involved, name everyone you can and with the best and most accurate name you can.
So unless a rental unit is being like, I don't know, like stripped down to the studs and someone's moving their stuff around, when I might ask for full month's compensation, do you guys have your own formulas for estimating? Like I've seen 60% decisions. If I'm in a rush, I file a monetary worksheet with like 50% a month for whatever amount of months, and then I will submit evidence or amend it later. Is there a rule of thumb you use?
Whatever you can put together a reasonable argument to justify. Arbitrators, it's total discretion. It's pure random chance effectively that you can kind of influence by putting a number before them and giving any kind of justification for, you know, if you want to go by like square footage of the unit they couldn't use or percentage of time they couldn't live there and use that as a basis, you could try that. But really it's up to them. I think I very clearly remember that case where we had put together this reasonable justification for whatever percentage, and the arbitrator just repeatedly asked, well, why this number? Why this number? It's like, well, here's the kind of slapdash thing we put together, but they wanted something else. But there isn't anything else. There's unfortunately no rule of thumb other than use your best judgment, put something together that's reasonable. And also remember, you can only be awarded less than what you asked for. You can't be awarded more. So, you know,
You can.
well, you can, but it's patently unreasonable,
Oh,
probably.
it could be.
It could be patently unreasonable. So better to ask for a bit more than you actually think you could get and tell the arbitrator that they have their discretion to award less if they think less is owed.
Yeah, I think it may, like, in this case, it was patently unreasonable because the arbitrator didn't say why they were awarding the amount. I think you could still argue that it's not patently unreasonable to award an amount greater than what was asked for, but it's dangerous. It may be patently unreasonable or maybe procedurally unfair. If a landlord could argue that they didn't have a chance to prepare for defending against that claim or whatever. It's weird.
Cool. You done? Thank you. Thank you, guys.